Well, hello and a very warm welcome to Quadrant's annual Piraeus shipping event. I say warm, I'm pretty sure it's much warmer where you are than it is where we are here, as we all sit in chilly London, rather than where we used to come, which is Piraeus Marine Club. We may not be with you in person, but I am confident that the panel of speakers that you see on your screen now and the program we have for discussion will be as lively as ever, which is very good news for you as the audience. It's rather less good news for me as the moderator, as I have to try and keep everyone to time and under control, but I'll do my best. All going to plan, the format of today is that each speaker will speak for about 12 minutes. Notice how I've reminded everyone of their timings there. And then we will close with a question and answer, hopefully more of a panel discussion on the topics that they have presented. If you are not the speaker, please can I ask that you switch off your microphones for the duration, but I do encourage you to use the chat functions to post your questions, comments, or observations on the chosen topics, and then we will pick those up in our closing session. We do have a wide range of topics, so I'm confident that you'll find something to say about one of them. All that leaves me now is to say something about our speakers. The truth is we're extremely fortunate that we have 5 Quadrant silks nonetheless to speak today. So they really do need no introduction from me, and I'll keep it brief before each speaker gives his talk. The first speaker is Michael Howard QC, leader of the Admiralty Bar and recognised in the legal directories for his long-standing experience in shipping work. And we are very fortunate today that we will now get the benefit of that experience as Michael looks forward to the future and poses the question, electronic bills of lading, where do we stand? So over to you, Michael.
Thank you, Nichola. Legally speaking, electronic documents are documents. Life would be impossible if they were not. But electronic bills of lading are not bills of lading. Why is that? Well, there's a practical reason and a legal reason, and the two are, of course, closely connected. The practical reason is that the bill of lading is a document of title, moreover, which gives the right to possession of the subject matter of the bill to whoever happens to be in possession of it. And this right to possession has enormous commercial consequences in terms of delivery, payment of the price, security for payment, and so on. The legal reason is that there is a general rule of English law that there can be no legal possession of an intangible. It is possible to assign contractual rights, but there is in law no possession of them. The distinction is between choses in action, or rights, and chattels. Only the latter could be the subject of possessory interests. Indeed, before the 20th century, and even my experience on which Nichola has laid so much stress doesn't extend before the 20th century, but I can tell you that before the 20th century, chattels were also called choses in possession, to distinguish them from choses in action. And so that the very factor which made a chattel was the right to possession. It might be thought that already by the year 2000, we had come to live in a digital world and that this distinction should be consigned to history. But it was reasserted in this century in the context of confidential information in OBG and Allen in the House of Lords in 2008, and in the context of possessory liens in Your Response and Data Team, Business Media Limited, in 2015 in the Court of Appeal. These cases effectively meant that electronic bills of lading could not be introduced into general commercial practice, as they would be ineffective as a means of transferring legal rights. Now, it's obvious that the interests of efficiency in every type of business are served by the creation of a regime which permits people to use computers and the internet, rather than to have to acquire boxes full of forms and then to ensure that they're available to everybody who is possibly going to be taking an active part in the transportation process. To ensure that they go out in the right numbers, are signed by the right people, and then only the right people come into possession of them thereafter. There's something a bit odd about a situation where a housewife in Surbiton can order her favorite nail varnish, which happens to be made in Thailand, by simply going to her mobile phone during an advertisement break and ordering them on Amazon without more. To avoid a Twitter storm, I should say that a bouncer in Scunthorpe, who may well be male, could also do the same if he wanted to acquire that nail varnish. And you contrast that with the way in which shippers have to produce 3 pieces of paper, which have to be sealed and kept intact by agents, carriers, banks, insurers, customs officers, warehousemen, and many others. There's been research into the cost savings which could be achieved by trading electronically rather than by paper bills of lading, and it's estimated that there are savings of hundreds of billions of dollars a year to be made. And there is quite an environmental dividend to be earned by going digital, because the 3 master copies of the bills of lading are, as pieces of paper, are just the cherry on the top of an enormous pudding of underlying documentation. So the advantages to be derived from replacing paper with electronic documents are of benefit to everyone, producers, sellers, and buyers, as well as the immense diversity of actors in the shipping industry worldwide. But they can't be achieved without the widespread implementation of a regime where the use of such documents is lawful and effective. And the question arises, how is this to be achieved? We had a system of trading which developed in the Middle Ages and came to be adapted for the age of steam and telegraph in the 19th and 20th centuries by commercial interests, international organizations, and national governments acting together. And these same 3 groups are active today in promoting e-bills and change, which has been gradual and piecemeal up till now, but seems likely to accelerate in the near future. First, the commercial interests. These are the people who are primarily and directly affected by the nature of the documents which are used in their transactions. If electronic bills of lading are a more efficient and secure method of conducting trade, all of the long list of types of enterprise I have mentioned will be pressing both individually and together for them to be adopted. While there's no legal framework in place which guarantees their efficacy, they cannot take the risk of using them. Some large organizations have formed their own private members clubs, in effect, for dealing with each other on the basis of electronic documents. They have given rise to such systems as Bolero, eDocs Online, WaveBL, and Cargo X, some of which date back to the last century. Maersk and IBM got together to produce TradeLens, which has absorbed other large organizations into its membership and can, within the limits of that membership, trade electronically. So, but these systems have their own take-up, but they have the obvious disadvantages stemming from the fact there is no overall legal validation for the arrangements. In the first place, they're confined to their own particular constituencies, so they're not available to cover transactions with outsiders. And this means that there have to be very complex arrangements to deal with the 2 classes of case. There have to be parallel sets of procedures to cope with them. And there also have to be procedures whereby the 2 sets can be merged in an appropriate case. So what has happened is that there has been quite elaborate legal structures created in order to achieve what's intended to be a simplification of the process. The enormous commercial power that some companies wield would enable them to use electronic documents more widely if there were a universal basis for them. And they would be able to do so whether or not their counterparties wish to adopt the practice. It would just be absorbed into ordinary commercial life. It seems overwhelmingly probable that Maersk and MSC and major shippers of bulk cargoes, whether mineral, liquid or gas, would be the first in line to take advantage of a system which is not confined to a small number of entities which have to sign up for the scheme in advance. The second group who are bringing about change are the international maritime organizations. And they have soft power, they can bring matters to governmental attention, they can respond to governmental initiative. They have the advantage of their status as apparently expert and objective figures, and their proposals tend to have authority because in the nature of things, they tend to have or to reflect an international consensus already achieved by the time they are formulated. And a useful byproduct of their work is that it reduces the scope for governmental posturing, whether on the international or domestic stage. Such organizations can advance the cause of any worldwide legal reform by two principal means. They can provide the text of international conventions, which are to be adopted by governments, or they can provide draft codes in the form of model laws. In the context of electronic bills of lading, the most important body is Unseaworthiness, which has already created two substantial bodies of what you might call potential law. The first is the Rotterdam Rules, intended to replace the Hague, Visby, and the Hamburg Rules. These include measures to promote electronic transport documents. They also illustrate the potential weakness of international organizations, because the Rotterdam Rules cover an enormous amount of ground and have had very little general acceptance for a number of reasons not connected with electronic bills of lading. The second achievement of Unseaworthiness is the model law on electronic transferable records, MLETR, which has been adopted by a number of states. And this has not proved popular, no doubt, because it's long and detailed and complicated in the same way. The third group, governments, have their own interests to serve as they're eager to generate trade to and from their country. And Singapore, Bahrain, and Abu Dhabi, South Korea, China, and Japan are examples of countries which have already adopted legislative measures, directly or indirectly, supporting electronic bills of lading. But national governments can't be confined to parochial considerations because of the international nature of the institution with which they are dealing. In the United States, the UCC, Universal Commercial Code, has not been given national force, but it has been adopted by every single state. So it's recognized throughout the country, the process being somewhat similar to the adoption of an international convention. But again, there are the disadvantages that these codes and the contract underlying these contractual and state-directed changes have the same disadvantage of being detailed and complex. However, the English Law Commission has followed a radically different path and has produced a draft statute. That document is less detailed and much more concerned with fundamental principle. It might be said that the cases I mentioned earlier, the data team case and the OBG and Allen case, were cases where the courts were rather timorous and shrank from the idea of introducing a new concept of possession because they couldn't foresee the consequences. The Law Commission has been bolder. In the wake of a pretty lengthy and well thought out report, which gave the practical arguments for encouraging trading on electronic documents, it's come up with a draft bill, which is just over 2 pages long. And this stunning brevity has been achieved by negative means, that is, by removing restrictions. Essentially, the bill enables electronic documents to be the subject of legal possession, and thus transferable in the same way as if they were physical documents. This power is available only in relation to what are called trade documents, which are defined in section 1 of the draft bill and form a list familiar to all those in the shipping industry. Section 1.4 also defines the circumstances in which a person has control of a trade document. It says a person has control of a document if the person is able to A, use the document, and B, transfer or otherwise dispose of it. This sounds almost too simple to be true, and that simplicity is emphasized by section 2.1 of the bill, which provides that a person who has control of an electronic trade document is the person who has possession of it for the purposes of any statutory provision or rule of law. And really, with one bound, Jack was free. Or to use another antique metaphor, the Gordian knot was cut in 2 short paragraphs. It will now be possible to have possession of an electronic document, such as a bill of lading, and a transfer of control will amount to a transfer of possession. This is still only a proposal, but the noises emanating from the government are actually favourable. No, nothing can be said to be certain, particularly in the way the government's been carrying on in the last few weeks. The Minister of Transport is quite dynamic and, at least to my eye, seems to have some grasp of the needs of the shipping industry. There is a very real possibility that the draft bill will be presented to Parliament within the next 12 months. If suddenly there is in place a legal regime whereby English law contracts can countenance the use of electronic bills of lading, it's reasonable to anticipate a mushrooming of their use, if not within months rather than years, at least within years rather than decades.
Thank you, Michael, and for keeping to time. My job's made so much easier. Thank you, that was really interesting and actually answered one of the questions and answers that we've already had posed, which was really to say the bills of lading have been in the market for a long time, but not widely adopted. Is there an action plan? Well, you set out the action plan very well there, at least as far as English law is concerned.
Well, it'll apply to English law contracts. So one of the Law Commission's objectives is the nationalist one of making people keep on using English law.
Well, quite right from an English lawyer's point of view. Thank you. Our next speaker, Simon Rainey QC, is a star individual. And to give a recent quote from one legal directory, is undoubtedly one of the top shipping barristers on his feet in London, phenomenal on his feet, and a barrister you can 100% rely on. Now, I see he's sitting down today, but I'm pretty confident that we can rely on this top shipping barrister nonetheless, as he looks at the classification of terms in shipping contracts and asks whether the judicial preference for innominate terms over conditions has now made it too difficult for an innocent party to terminate for breach. Thank you. Could I ask you, Michael, just to mute your microphone while Simon's speaking? Thanks.
Thank you very much indeed, Nichola, for that embarrassingly good and nice introduction. I've only been set up to fail now, and people listen to me sitting down rather than being on my feet. This afternoon, I want to talk about the recent trends in the authorities making it difficult to terminate shipping contracts for breach of contract. Shipping contracts typically raise in acute and often urgent form the vexed question whether a breach of contract by one's counterparty gives one a right to terminate the contract, be it charter party, ship sale MOA, or any other form of shipping contract. But perhaps it's particularly in relation to charter parties, where market volatility and the movement upwards and downwards of freight and hire rates makes parties focus on the possibility of escaping what has become a bad bargain on the market by seizing on the other party's breach. And so that urgent question, which shipping solicitors and barristers and P&I clubs get asked, in my bitter experience, typically at 5 p.m. on a Friday or on a nice sunny bank holiday weekend, on these facts, can we terminate? We need to know now. Well, the analysis is easy enough, even if the answer to the particular questions is rather trickier. Very straightforward. Firstly, is the term alleged to have been breached in law a condition of the contract? If it is, then the gravity or the effect of the breach is irrelevant. Any breach will give you a right to terminate. But if it isn't a condition, then is the breach or series of breaches, if more than one, sufficiently serious to amount to a repudiation of the contract if it's past, or if it threatens a breach for the future, a renunciation of the contract. And the recent the cases, both in the commercial court and in the Court of Appeal, demonstrate that satisfying either of those two bars is going to be difficult, very difficult. Let me start with conditions of the contract. In practical terms, unless the term in question is a timing obligation on which substantial performance is in some important way dependent, discussed in the old case of Bunge and Tradax in 1981, then a party has, in my view, very little realistic prospect of establishing that a term is a condition unless it clearly and expressly says that it is and uses the word condition. Let me give you two pretty graphic examples, the spar shipping case and the Arctic case, in which I was lucky enough to appear on both sides of the equation. As most of you will know, spar shipping concerned a breach of a term in a time charter party for the payment of hire, perhaps one of the most important and most central obligations one can have in a time charter party. And there was some considerably strong support for the view that a term as to the punctual payment of hire in full and on time was and should be a condition. Hire is the lifeblood of the owner. How often have we heard that being said? Who needs it to cover running expenses? And that was precisely the reasoning that was applied in 2013 by Mr. Justice Flo in the Astra, where he said it was crucial for commercial certainty that people knew where they stood. In spar shipping, both Mr. Justice Popplewell at first instance and the strong Court of Appeal rejected that argument, saying that it was firmly of the view that the payment, the term as to payment of hire was not a condition. Now, I don't want to go back over the merits of that dispute, but I think what's important from spar shipping is to identify the technique of interpretation which the court adopted and which will be adopted for any case when someone is trying to argue that a term is a condition. There are three main strands to what the Court of Appeal said. First, one starts in every case from the strong presumption that a contractual term is an innominate term unless it is, as they said, clear that it is intended to be a condition. Secondly, and importantly, I think, where the term in question can be breached in different ways, from the trivial to the serious, or where the effect of the breach can vary from the minor to the major, then that is to be taken as a very strong indicator that the term is not and cannot be a condition. Why? Because the parties cannot reasonably have been presumed to intend that the drastic sanction of termination would be available for a petty or trivial breach as well as a major one. So payment of hire a few hours late or short by some small amount can't possibly make any difference in real terms. And so for Lord Justice Hamblin, that was critical because that is the hallmark, as he put it, of an innominate term. And thirdly, certainty and the importance of knowing where one stands and all of that had a lot of cold water poured on it by the Court of Appeal, because you need to balance certainty against the drastic consequences of termination for a breach which really doesn't merit it or deserve it. And those principles were applied in the case of the Arctic. The issue which arose in that case concerned the effect of a clause in the demise charter party as to maintenance and operation. But in the middle of that clause, someone had stuck these words: the charterers shall keep the vessel with unexpired classification of class and with all other required certificates in force at all times. The class certificates expired shortly before the vessel went into dry dock, and it was argued that they were entitled to charters were entitled to terminate at the long-term demise charter party. Interestingly, Mrs. Justice Carr, at first instance, held that the importance of being in class, central to the operation and status of the vessel, meant that the class part of Clause 9 was a condition. And she justified her reasoning by reference to the analysis in spar shipping and the seriousness of the consequences of not being in class. Off it went to the Court of Appeal, and the Court of Appeal disagreed with Mrs. Justice Carr and said that the class condition was not a condition of the contract. And the reason it said that was it applied the hallmark test. Loss of class, said the Court of Appeal, was capable, certainly, and it recognised it, of having very grave consequences for flag, financing, insurance, in some cases, but not in others. And it looked at the facts of the particular case before it and said that the fact of class expiring had no real consequences at all, and therefore it couldn't have been presumed that the parties intended that to be a condition, any breach of which entitled the right to terminate. So the recent cases tell us that unless you're in Bunge and Tradax timing and interdependency country, resort to a condition in a shipping contract is really pretty hopeless. Is the approach of the court easier when one's grappling with trying to show a repudiatory breach or a renunciatory breach? So we've got our anominate term, there's a breach of it. What do we have to show to be able to terminate? It's usually the tricky question that comes in on a Friday afternoon. I think my answer to that is yes and no. Let me take the no bit first. The cases I've been discussing show that the bar is set very high for establishing that a breach or even a series of breaches entitles one to terminate the shipping contract in question, typically a charter party. As we all know, the test in that very unhelpful phrase is whether the breach goes to the root of the contract. And we often agonize about what that means. But I think if we go to sparse shipping, the Court of Appeal set out a very comprehensive and detailed analysis of what that means and how you work it out. And effectively, the starting point, when considering the seriousness of the breach, is what is the benefit that the innocent party is intended to obtain from the performance of the whole contract. So the Court of Appeal said that the failure has to be compared, the breach or the failure has to be compared with the whole of the consideration of which the other person is getting under the contract, not just part of it. So really you have to find a breach which is substantially inconsistent with the whole scheme of the party's obligations under the contract, effectively blowing out the middle of the contract, leaving nothing around except the edges. And that's very, very difficult. Take an example of the very recent case of the Sea Challenger, currently on its way to the Court of Appeal, decision of Mr. Justice Foxman in December of last year. Allegation of renunciation by a series of repeated breaches by the owners of a 2-year time charter party, which the charter said entitled them to terminate after 8 months. Failure to exercise due diligence to clean the hull. A massive overconsumption of fuel in breach of the warranty. Failure to investigate the overconsumption. Failure to maintain the turbocharger. Quite a series of breaches. And looking at whether the whole of the benefit of the contract had been deprived, and Mr. Justice Foxton held that it plainly was not a repudiatory breach. So one really is having to establish a breach which makes the whole performance of the contract radically different, and that's not an easy ask. I said, is it easier to terminate? And I said the answer is yes and no. I've dealt with the no. What about the yes? I think sparse shipping is a very good illustration of the sensitivity of the commercial court to the nature of the obligation being breached. In one sense, Mrs. Justice Carr's decision at first instance in the Arctic was the same. She was concentrating on the importance of class. In sparse shipping, the Court of Appeal concentrated on the importance of punctual payment of hire. The obligation to pay hire, while not so critical as to be deserving of classification as a condition, was nevertheless treated by the Court of Appeal as a very critical obligation indeed, where very small deviations in a pattern would amount to repudiation or renunciation. And that's important because I think we forget that if you look at other non-maritime contracts where regular payments are required, it's very, very difficult to terminate for repeated non-payment, even where someone says, I'm not going to pay you until the end. We've got cases like Ballylas and Januzaj, which was relied upon by the charterers in the Court of Appeal. The Court of Appeal had nothing to do with that and rejected that line of authority. Why? Because of the commercial importance of hire to the time charter. And I think a non-shipping judge, the Master of the Rolls, Sir Terence Etherton, in sparse shipping said it best. The charter has evinced an intention to turn the charter parties into something radically different from its terms, namely, from a contract for payment in advance for services to be thereafter provided by the ship owner into one for payment in arrears, in effect, for the performance by the ship owner of his services on credit. And so, while it may be difficult to establish a repudiatory breach in relation to other obligations, I think the message from sparse shipping in the recent cases is that in relation to non-payment of hire, I think it's become easier. So I ask, is the court too hostile to termination of shipping contracts? Well, it depends which end of the telescope you're looking at that question from. I think what we see from the recent decisions, the Sea Challenger last year is a very good example of it, is the court thinks that termination is and should be a matter of last resort, not a bolt out of the blue in trivial circumstances just because the market's gone up or gone down. It should be difficult to terminate, and the court is deciding cases on that basis. And when people are considering, well, that makes matters uncertain, I think the message from the courts is, if parties want to legislate for a right to terminate, they should do it expressly in the terms of their contracts. And there was an interesting illustration of that in the Spa shipping case. In the Spa shipping case, Mr. Justice Popperwell pointed out that since the earlier decision of Mr. Justice Brandon de Brimney's, which held that hire was not a condition, the NYP form and other forms had gone under repeated revision, and no one had done anything about it. Interestingly, after Mr. Justice Popperwell's decision, but before the decision of the Court of Appeal, the NYP 2015 form was brought in with an amendment, as it were, to put back the clock to Mr. Justice Flo's result in the Astra. And I think what that shows is that if you want to make a term important, your remedy is in the drafting of the contract. Take, for example, the Arctic. If class was absolutely critical, then you say any deviation from class, any successor of class will give an immediate right to terminate, and possibly an immediate right to terminate and claim damages. And I think that's the message which is coming down from the court in other contexts too. I leave you with the closing words of the recent decision of the Court of Appeal in the Eternal Bliss. The Eternal Bliss, as most of you will know, concerns the issue whether demurrage is an exclusive remedy for failure to load and discharge within the lay time, and whether it covers all losses or whether it only covers the loss of the use of the vessel. So Justice Andrew Baker held that it covers only the loss of the use of the vessel. The Court of Appeal disagreed and held that it covers all losses. But it ended its judgment, very interestingly, by saying this: to allow the appeal will produce clarity and certainty, while leaving it open to individual parties or to industry bodies to stipulate for a different result if they wish to do so. If our judgment does not meet with approval of the market, and I think the jury's out on that, it should not be difficult for clauses to be drafted stating expressly that demurrage only covers certain stated categories of loss. And I think likewise, it is not difficult for commercial parties who want, when they're concluding a contract, to say that a term is important enough and that any breach of it gives a right to terminate, to use the proper language to bring about that result. So I don't think it's too hard to terminate. I think it's the commercial court is taking the right approach, and it's up to the parties to find their own solution. Whether they do or whether they don't is a matter for them. Thank you very much indeed.
Thank you, Simon. That was a very interesting talk on termination, very balanced, as one would expect. Our next talk is turning from the impact of judicial thinking on our clients' contracts to the impact of sanctions. And our next speaker, Nigel Cooper QC, has been most recently described in the legal directories as having an excellent commercial understanding of how the shipping trade actually works, which will no doubt come to the fore as Nigel discusses the ongoing uncertainties which arise in connection with sanctions, and particularly in relation to P&I cover and claims. So if I could hand over to Nigel, please. Thank you.
Thank you very much, Nichola, for that introduction. You're quite right. What I want to talk about is sanctions, a topic which, despite the frequency with which it comes up nowadays, continues to be very opaque in terms of their scope and ambit. But that said, they also continue to present a significant risk for the shipping industry, and particularly insurers, for a number of reasons. First of all, sanctions are a popular economic weapon. They're seen as being a powerful economic foreign policy tool by government. Second, the number of differing regimes that rely on sanctions to achieve their international aims. Of course, we all know the UN, the US, the EU, the UK all have sanctions regimes. And of course, this year we've also seen the impact of sanctions imposed by China. Third, the geographic scope of sanctions. And fourth, the range of persons, entities, and transactions caught. All of this leads to a complex web of regulations, both in terms of defining who or what is caught by a sanction, and also what are the consequences of a failure to comply. Now, the added twist to this mix is, of course, the potential extrajudicial effect of sanctions, and in particular those imposed by the US. And one of the most notable risk factors that we'll all be familiar with is the fact that while a transaction may not itself attract sanctions, may not itself be unlawful under the law of the contract as such, it is still a potentially sanctionable, or it still raises potential sanctions risks because it requires payment, the transaction requires payment through the US banking system, and therefore engages or potentially engages secondary sanctions. All of these problems reflect risks to the shipping sector, and also are highlighted by the ongoing interest of the regulators as to what is happening within the shipping industry. And that in itself is reflected by the guidance issued by both OFAC and the UK Treasury last year for the shipping industry, with both authorities emphasising the enhanced due diligence standards expected of the industry, and expressing particular concern in relation to ships going dark by turning off their AIS, and in relation to the use of STS transfers. Now, this interest from the regulators, combined with the wider risks, certainly to ship owners, is why we are now seeing both more cases before the courts, and particularly the commercial court here, but also more cases, more and continuing guidance from, first of all, the P&I clubs, as to the steps to be taken by way of loss prevention to avoid exposure to sanctions risks. And of course, one example of that is the recent guidance issued by Skuld in the context of STS transfers. Similarly, you have the efforts of Bimco to develop their suite of clauses, which are intended to reflect the current status of the sanctions environment, and to allocate risk between the different parties who might themselves be caught by sanctions. And this, in a sense, is a reflection of the concern within the industry that bespoke clauses used by different players create their own uncertainties as to their effect, and is often the case in other sectors of the shipping industry, the reason to encourage standard clauses. And two very recent examples of this are, first of all, the Bimco sanctions clause for the container trade 2021, very new clause, and drafted to reflect the particular problems that the container trade experiences in the context of sanctions, given, first of all, the multiplicity of parties involved in shipments, but also the difficulties associated with identifying what, for example, is in a container once it's been packed. The clause contains mutual warranties that neither owner nor charterer, nor parties above or below them in the contracting chain are sanctioned parties, and breach gives rise to a right to terminate or to claim damages. There's also a warranty that charterers will not carry sanctioned cargo or cargo that they should have known is sanctioned. And that warranty carries with it quite a strong indemnity and hold harmless provision. And that reflects the intention behind the clause, that it is the operator in a sense who is responsible for containers coming on board, who is going to face the focus of making sure that cargo loaded on board doesn't engage the sanctions regime. One of the other interesting aspects of the clause is the wide scope of sanctioning authority. And so it doesn't just look at the impact of sanctions imposed by the primary authorities that have sanctions regime, the primary states that have sanctions regime. It applies more widely to states that can impose sanctions or may impose sanctions. Another illustration of recent Bimco activity is the Bimco Ais Switch-Off Clause 2021. And again, this is a direct response to the OFAC guidance, and reflects the suspicion that can apply to ships that turn off their AIS when they're trading in certain parts of the world. And of course, there are circumstances. There's a tension between, on the one hand, the potential operational benefit to switching off AIS if one is in waters that are beset by piracy, combined with whether or not, first of all, that complies with the ship's seaworthiness obligations, but also the suspicion it might give rise to that the ship is engaged in an activity that would attract the attention of the sanctioning authorities. The Ais Switch-Off Clause requires the owner to warrant compliance with the IMO guidelines on operational use of AIS in the previous 6 months, and requires charterers not to request that the AIS be switched off, or that the vessel conduct STS operations with a vessel which has not in the last 6 months complied with the IMO guidelines. Now, there's no doubt in this case, in the context of these clauses, as to their effect. If a party is in breach, there is a right to terminate, or indeed the owner may reject the request if the owner is asked to switch off the AIS or engage in a non-complying STS transfer. Of course, clauses such as these are one route by which parties can protect themselves against the risk of being caught by sanctions. But one also has to keep in mind that the transactions which are in breach of sanctions are also likely to engage the doctrine of illegality. And that doctrine does give rise, or can give rise, to a prohibition on the performance of a contract which is contrary to a sanctions regime, or indeed performance of which is caught by a sanctions regime. Now, the application of that doctrine, the application of the rule in Re Raleigh Brothers, is not straightforward. But at its simplest, what it essentially says is that an English law contract will be unenforceable if performance is prohibited by the law of the place of performance, and that the court will not enforce a contract if performance of that contract necessarily requires an act in a friendly foreign state, which would be unlawful by the law of that state. Now, increasingly, therefore, the focus is whether or not performance of the contract does require an act which would be unlawful by the law in the state in question. And indeed, the most obvious example of this, and the one that has most given rise to the majority of the case law, is where there is a contract price or other payment required in US dollars. And that payment cannot be made without engaging secondary sanctions or US secondary sanctions. But one of the questions that will have to be tested in those types of cases is whether a party can still fulfill, under the terms of the contract, their payment obligation, either by paying in an alternative currency or by transferring dollars in an alternative means. And certainly the recent decision in Bimco, San Juan and PDVSA, which concerned claims in debt under 2 credit agreements, was a case where PDVSA were claiming to be prevented from paying their debts, either as a matter of construction of the relevant contracts or pursuant to the doctrine of illegality, because the payment was prohibited in the place of performance. The court rejected the construction argument, and again, it emphasizes the need to be careful about specific wording, because the court held that the clause in question was not a prohibition on payment. It was simply a negative covenant that PDVSA would not pay debts using the proceeds of activities that were sanctioned. The court also rejected the attempt to rely on the rule in Re Raleigh Brothers. Now, that was first of all on the basis that payment could be made in limited circumstances if PDVSA had obtained a license to make the payment, and they weren't able to satisfy the court that they had taken sufficient steps to try and obtain that license. But the court was also went on to say that they wouldn't have been prepared to say that PDVSA had made out a good case of impossibility in any event. And that emphasizes the factual context of many of these cases. Namely, it isn't simply enough to say that, oh, the transaction in question or payment in question is caught by the sanctions. One will have to evidence why, and why there is no alternative means of payment or fulfillment of the contractual obligations that may not be caught by the sanctions regime. Now, that case concerned a commercial agreement, a financial agreement, but much of the focus surrounding the impact of sanctions continues to be the effect of sanctions on insurance coverage. And on one level, this may be a question of whether measures taken, for example, by a ship owner to avoid detection have breached insurance warranties aimed at ensuring the safe operation of the ship. Issues can also arise as to whether or not the nature of the sanctioned activity is such that there is no cover at all in respect of the risks associated with an activity, or alternatively, what is sought is a payment of the claim where that payment might be in breach of relevant sanctions. Whatever the question, one of the principal difficulties which arises is that on the whole, insurers, certainly in the P&I context, each have their own bespoke sanctions clauses. Accordingly, it's a matter of construction as to, in each case, as to whether cover is in place or whether insurers are entitled to either pay claims or indeed refund premiums or other reimbursements that might be due under the terms of the cover. Nevertheless, a few common themes can be drawn out. First of all, very clear words will be required to abrogate or extinguish a payment obligation. The more likely outcome is that a clause which protects an insurer from paying a claim, if to do so would risk triggering sanctions or prohibitions imposed by foreign legislation, will be construed as suspensive. Again, what also stands out from the authorities is that each case will turn on its wordings, but in the absence of express wording providing wider protection, where a sanctions clause is only engaged if the claim exposes the insurer to risk of sanctions, then the evidence must establish that there is in fact no such risk. And of course, in each case, the courts will look to try and balance the rights of a party, including insurers, to protect themselves against the risk of being found to be in breach of sanctions legislation, against also at the same time the risk of preventing a party in default using alleged sanctions to avoid legitimate payment obligations. Now, those cases can be seen in, of course, cases such as those themes can be seen in play in cases such as, of course, the now familiar Mamang Cochet mining and Aegis, the decision of Mr. Justice Tier back in 2018, and of course in the decision last year of La Mesa and Synergy. But perhaps of most recent interest is the decision in the Panamax Alexander case, where the court was reconsidering the requirement under the Admiralty Solicitors Group Collision Jurisdiction Agreement, AGS2, that each party provides security in a form reasonably satisfactory to the other. And in that case, the Admiralty Court held that the inclusion of a sanctions clause in a P&I Club letter of undertaking was not on its own sufficient to justify a party rejecting that LOU on the basis that it was in a form which was not reasonably satisfactory. The court held that both the recipient of the LOU and the insurer providing the LOU would be alive to the practical difficulties caused by a transaction or a collision for which for whatever reason had a nexus with a country or party for which there was a risk of sanctions. And therefore, of course, it would be in both parties' interests to be seeking to protect themselves against that risk. Now, the interesting follow-on conclusion from that case was that when the court went on to hold that even notwithstanding its finding on that what was reasonably satisfactory, there was no implied term requiring an arresting party to accept such a form of security. So this last case, the Panamax Alexander, shows the types of issues that are still going to arise in the context of sanctions, particularly within the field of insurance, and the difficulties that are associated with looking at what wordings are going to mean in particular cases. But I'm sure that further guidance is going to be forthcoming. In any event, I can see that I've overrun my time, so I'll come to a close there. Thank you very much.
Thank you, Nigel. Before we go on to the next speaker, could I just remind the audience that if you do have any comments, observations, or questions which are relevant to the topics which the speakers are giving their presentations on, then please do post them either in the chat, or I notice there's a question and answer box too. So either of those channels I'll be monitoring during the course of today, and we'll bring those relevant to the topics we're discussing back into the panel closing discussion after all the speakers have given their talk. Moving on now to the next speaker. Nigel, could I just ask that you turn your microphone off? Sorry.
Absolutely, sorry.
Thank you. Our next speaker is John Russell QC. Last year, John was named Shipping Silk of the Year at both Legal 500 and Chambers and Partners Bar Awards. So I'm sure those were good evenings for John. And that didn't stop him this year either, because he's fresh from his Supreme Court success in the landmark decision of the CMA CGM Libra. Hopefully from now on, we'll just call it the Libra. And he is here today to discuss the impact of that case on other disputes where allegations of defective passage planning and unseaworthiness are made. So over to you, please, John.
Thank you very much, Nichola, and good afternoon to everybody who is watching or listening in Greece. Yes, so I'm going to talk about the Libra case and the interrelationship between passage planning and unseaworthiness. And in essence, the Supreme Court has upheld the decisions of the Court of Appeal and the Admiralty judge to the effect that, first, a defective passage plan can render a vessel unseaworthy. And if the passage plan is defective before the commencement of the contractual voyage, that can constitute a breach of Article 3.1 of the Hague Rules or the Hague-Visby Rules. And secondly, in those circumstances, the carrier or owners are liable for the failure of the master or the navigational officers on board the vessel to exercise due diligence to prepare a proper passage plan. And that is so even if the owners themselves had properly equipped the vessel with charts and notices to mariners and so on. So in this talk, what I'll do is I'll touch briefly on the facts of the Libra case itself, then look at the reasoning of the decision in the Supreme Court, and then consider the impact that the decision is likely to have on future cases. The Libra was a large container ship, and she grounded on the 18th of May, 2011, while leaving the Chinese port of Xiamen. The vessel grounded when, for reasons that were never really satisfactorily explained in the evidence, the master decided to leave the dredged fairway for a short period. Now, importantly, there was a notice to mariners which warned that there were uncharted shoals outside that dredged fairway, and the vessel, rather unhappily, grounded on one such uncharted shoal. During the passage planning process, the master and third officer had failed to record that crucial warning from the notice to mariners on the working chart or in the pro forma passage plan document. And the judge was able to conclude on the basis of some evidence that the master gave in cross-examination that if the warning had been marked on the chart, the master wouldn't have attempted to leave the fairway during the departure and the grounding wouldn't have occurred. He held, therefore, that the absence of the warning on the chart meant that the passage plan was defective, and he held that the vessel was unseaworthy, applying what's called the prudent owner test. He held it was inconceivable that any prudent owner would have allowed the vessel to go to sea without the warning being marked on the chart. And then he held that the owners were liable for the master's failure to exercise due diligence in the preparation of the passage plan, even though the owners themselves had made sure that proper charts were on board and that the notice to mariners was on board. The Supreme Court has now, in essence, upheld the findings of the judge at first instance, which had also been endorsed by the Court of Appeal. In the Supreme Court, the owners argued for what they called a category-based distinction between unseaworthiness on the one hand and navigation and navigational decisions on the other. They said that preparation of a passage plan was an act of navigation, and that simply put it in a different category from unseaworthiness, such that the defective passage plan couldn't constitute unseaworthiness. In a related argument, the owners also argued that a defective passage plan didn't constitute unseaworthiness because it wasn't an attribute of the ship. They said that there was an attribute threshold to unseaworthiness for the purposes of Article 3.1, and they said that a defective passage plan didn't satisfy that attribute threshold because the passage plan was merely a record of navigational decisions, and navigational decisions weren't attributes of the ship. And then in the alternative, a sort of second string to their bow, the owners argued that even if the vessel was unseaworthy, the owners had satisfied the obligation to exercise due diligence by making sure that the master had all the charts, notices to mariners, pilot books, and other navigational tools that he required. Basically, they said that if the owners provided the master with all the tools that he needed to do his job properly, that satisfied the due diligence obligation, even if the master didn't then use the tools properly and the master failed to exercise due diligence. The Supreme Court has rejected all those arguments. The fundamental point that emerges from the Supreme Court decision is that the Hague Rules and Hague-Visby Rules regime differentiates between, one, unseaworthiness before and at the commencement of the voyage, that's Article 3, Rule 1, and secondly, navigational fault, which occurs during the voyage. So in relation to unseaworthiness, which occurs before and at the beginning of the voyage, there's no exception to liability if the vessel is unseaworthy, simply because the unseaworthiness is something to do with navigation. There is no category-based distinction between unseaworthiness and navigation. Therefore, negligent navigation or preparation for navigation prior to the voyage commencing can give rise to unseaworthiness in the vessel, just as much as, let us say, the chief engineer's failure to maintain the engine or to change the lube oil or matters of that nature. And the Supreme Court has said that, save in exceptional circumstances, which the court hasn't defined, so there may be scope for argument in the future there, save in exceptional circumstances, one simply applies the prudent owner test and asks, would the prudent owner have allowed the vessel to go to sea without remedying the defect? If the prudent owner would not have allowed the vessel to go to sea without the defect being remedied, the vessel is unseaworthy. And the Supreme Court has also re-emphasized the non-delegable nature of the due diligence obligation, so that owners are liable for a want of due diligence on the part of the master or crew, even if the want of due diligence lies in the carrying out of a navigational task, and even if the owners have ensured that the master and crew have all the tools that they need to prepare a proper passage plan and do the job properly. By contrast, once the voyage commences, Article 3, Rule 1, the unseaworthiness obligation no longer applies, and the exceptions in Article 4, Rule 2A do apply, including the navigational fault exception. What that means in relation to passage planning, I think is quite interesting, because it means that a negligent failure by the master before the voyage to prepare a proper passage plan may be a breach of Article 3.1 and lead to liability on the part of the owner if it's causative of a casualty. But a negligent failure by the master to follow a proper passage plan during the voyage will probably be excused by the negligent navigation exception. That's assuming that the master is competent and that there are proper systems in place so that the failure to follow the plan isn't caused by some sort of systemic failure. Now, it was that sort of that oddity that in some circumstances the owners are liable for a failure on the part of the master to exercise proper skill in navigation. In some circumstances they're liable, and in others they're not. That led to the owner's argument that there should be a category-based distinction. As I say, the Supreme Court has rejected any suggestion of a category-based distinction. It's all a product of the bargain that was struck in the 1920s conferences that led to the formulation of the Hague Rules. And the bargain that was struck was based not on a category-based distinction, but on a temporal divide between the seaworthiness obligation and then the various exceptions that apply once the voyage has commenced. In addition to those main findings, the Supreme Court has disposed of two issues that were left open by the Court of Appeal in the Libra case. Firstly, the Supreme Court has rejected any suggestion of an attributes threshold. It's not necessary to prove that the alleged defect lies in an attribute of the ship, save in those exceptional circumstances that haven't been defined. One simply applies the prudent owner test with no prior attributes threshold. And secondly, and related to that, the Supreme Court has held that the presence of dangerous cargo on the vessel can render the vessel unseaworthy. There'll obviously then be issues as to whether the owners have exercised due diligence in relation to the presence of dangerous cargo on board, or whether the fault is entirely attributable to shippers or other cargo interests. But as a matter of principle, a dangerous cargo can render the vessel unseaworthy. So that's the decision. What is the impact of the judgment going to be on future cases? Well, I think that the subject possibly to this undefined category of exceptional cases, the law and the points of law that the owners sought to rely on are firmly resolved in favor of cargo interests. So no category-based exceptions to unseaworthiness. Article 4, Rule 2 exceptions irrelevant to a claim based on Article 3.1 unseaworthiness, no attributes threshold, and the non-delegability principle reaffirmed, including in relation to navigational acts of the master and officers, if they render the vessel unseaworthy before the commencement of the voyage, and even in cases where the owners have properly equipped the vessel. That doesn't mean that there aren't going to be future disputes in relation to passage planning and unseaworthiness, far from it. But the battlegrounds are going to be on the application of the Libra principles to the facts of particular cases. And it seems to me that there are going to be two main battlegrounds in particular. The first is whether any defect in the passage plan is sufficiently serious to fall foul of the prudent owner test. It's a truism that passage planning is an art, not a science. There's no one single right way to plan a passage, no single right passage plan for a particular voyage. And really any passage plan can be criticized in some way. It's nearly always possible to improve a passage plan in some way or another. But the question is going to be in each case whether those criticisms will be such as to enable the court or the arbitrators to conclude that no prudent owner would have allowed the vessel to go to sea without a better passage plan being in place. And the other main battleground, I think, is going to be causation. There are two aspects to this. Firstly, whether the defects in a passage plan can be considered as causative at all, as a matter of fact. And obviously that's going to tie in with the prudent owner test, because the more serious a defect, the easier it will be to establish that it is causative. But more fundamentally, I think there's going to be a fertile debate in the cases as to whether a casualty is in truth caused by the passage planning itself, which takes place before the voyage, or by the navigational decisions that are taken during the voyage. Because a passage plan is never written in stone. It's always subject to variation to take into account of the actual circumstances that the vessel meets during the voyage. And so the question will be, what in law is the effective cause of a casualty? Is it the fact that the passage plan was defective at the outset, or is it the subsequent decisions that are taken by the master and crew during the voyage? Because of course, if it's the subsequent decisions that are the effective cause of the casualty, then they probably will be accepted by Article 4.2a. Just by way of closing, the decision in the Libra has obviously received quite a lot of comment as it progressed up the judicial hierarchy, and has caused a degree of concern among ship owners and P&I clubs in particular. I'm not sure that really it represents any radical departure from the pre-existing position. Certainly the judges didn't think so. Nor do I think that it is really such bad news for ship owners, as some on the shipowning side have seemed to suggest. While, as I say, that the legal principles are resolved probably in cargo interest favour, I think the issues are going to be very fact sensitive. And it's going to be quite difficult, I think, for cargo interest in particular cases, to establish that criticisms that can be made of a passage plan are sufficient to render a vessel unseaworthy, and secondly, that it is the passage plan and any deficiencies in the passage plan that are causative of casualties. So as I say, happily for the litigators, if not for the insurers, plenty of scope for argument in the future. Thank you very much.
Thank you, John. You won't be surprised to hear that your talk is generating quite a lot of questions and answers on the chat, so you might want to take a look before we do the panel discussion. Always the topical cases that generate the most questions and answers for our session, I find. Moving on from one John to another John now, our final speaker today is John Passmore QC, whom, to quote the legal directories, has one of the sharpest brains I have ever come across, extremely intelligent, together with an ability to translate the most complex of arguments into a structured, succinct, and flawless explanation. So we're going to get the benefit of John's intelligence today, as he's going to provide us with a guide to proving and avoiding parent company liability for contracts made by subsidiaries following the Court of Appeal judgment this year in Kawasaki against JKL. So if I could hand over to you, John.
Thank you, Nichola. So my talk is about the risk of parent company liability for breach of contract by a subsidiary. And there was an agreement between the speakers that we wouldn't have physical slides. So I've only got 2 slides and they're necessarily imaginary. The first slide is a picture of a horse. There's been a long debate about whether breach of contract can count as illegality for the purpose of unlawful means conspiracy. And according to the latest authority, it can. And the claimant need not be a party to the contract. The breach can be of a contract with a third party. And the authority for this is a case all about horse racing and betting on horses. So if you go to a horse race course, you see men, they are usually men, wearing camel coats, and they do usually wear camel coats, standing on boxes like soap boxes, and chalking up the odds for the horses in the next race on a small blackboard, which is next to them. And as the race approaches, and the horses either look sprightly or they sort of roll over and look as though they've got a stomach ache or something negative, presumably, to their ability to run around the course quickly, the odds change. And that happens in the run up to the race. And then, of course, when the race starts, the odds are fixed from then on. And then if you leave the race course and go into a high street and go into a betting shop in the high street, you see similar odds changing every few minutes in the same way. What you might not have realized is that the high street betting shops base their odds on an average of the odds at the race courses. And that average is recalculated and resupplied to the high street betting shops every few minutes before the race. And the case I'm talking about is the Racing Partnership against Done, D-O-N-E, decided by the Court of Appeal last year. The Racing Partnership had a contract with an owner of race courses, and under that contract, the Racing Partnership was entitled to collate the averages at the race courses and send them to off-course bookmakers. And it paid a fee to the race courses for that information, and it charged a fee when it provided that information to the off-course bookmakers. And obviously the aim was to make a profit. And well, so far so good, until Fred Dunn came along, as in Betfred, the owner thereof, and the owner too of Ladbrokes. He wanted similar information for his off-course bookmaker, particularly Ladbrokes, but he didn't want to pay the racing partnership a fee. So Ladbrokes used a subsidiary called SIS to get average odds, but not from racecourses, from betting exchange websites. And the racing partnership, missing out therefore on its fee, alleged unlawful means conspiracy. The judge found that Ladbrokes and SIS had combined with each other to obtain information from the betting exchange websites, and that they had done this to avoid paying fees to the racing partnership. So they had the requisite intention for unlawful means conspiracy. But what were the unlawful means? The only unlawfulness that the racing partnership could come up with in the end, there were 5 talked about at trial, but the one that was focused on appeal was that SIS's use of the information obtained from betting exchange websites that use of information was in breach of the terms and conditions of the websites. And the Court of Appeal decided by a majority that that was enough. Well, that seems very strange to me. The betting exchange websites owned the information they displayed. Those websites were entitled to do what they liked with that information. They had terms and conditions which restricted the use of that information by ordinary punters, people going on the websites to place bets. But the websites could, they didn't, but they could have made a deal with an industry entity such as SIS, and they could have sold SIS their information. As I say, they didn't, but they could have done. To put it another way, the racing partnership had no rights at all in relation to the information on the betting exchange websites, no right to a monopoly to supply that or similar information. And if Ladbrokes could find an alternative way of pegging their odds, good for them. But somehow the fortuitous breach of the website's terms and conditions made the whole thing an actionable conspiracy and converted what to me sounds like ordinary competitive behavior into a tort. So, as I said, I've only got 2 slides, and we're now going to say goodbye to the horse. The second slide is a picture of a moped flying along at high speed. On the back of the moped is a large black box, and on the large black box is a picture of a pizza. So the racing partnership case has decided at Court of Appeal level that breach of contract with a third party can count as illegality for the purpose of unlawful means conspiracy. And the question then is, what part does the breach of contract have to play in the story? How central must it be to what happened? The usual formula, which comes from Lord Nichols in OBG and Allen, in case you've already heard something about, is that the unlawful means must be, quote, the instrumentality by which the claimant suffers harm. I think that's a way of saying that the unlawful means, so here the breach of contract, must be instrumental. And I think that's a way of saying that the unlawful means, so here the breach of contract, must be causative of the claimant's loss. And in the usual way, in tort, but for causation is necessary, but it's not enough. What matters is the dominant cause. So the question then is the unlawful means, the breach of contract we're talking about, the dominant cause of the loss, or is it just an incidental part of the story? And for some reason, whenever judges reach this part of the case about an unlawful means conspiracy, they start talking about pizzas and pizza delivery mopeds. And they say this: a pizza delivery company which instructs its moped riders to break the speed limit so that they can deliver their pizzas more quickly than their rivals is not engaged in an unlawful means conspiracy. It seems that hypothesis is unappealable. It's always accepted that that is not an unlawful means conspiracy. So that's the yardstick. Supposedly because there is not enough causation between the instruction to break the speed limit and the loss to rival pizza companies. But if that's not enough causation, how is there enough causation between SIS's breach of the website's terms and conditions and the loss suffered by the racing partnership? Well, the answer, in my view, is that the racing partnership is wrong. But so far as I'm aware, there is no appeal to the Supreme Court. So we now have clear Court of Appeal authority that breach of contract with a third party is illegality for unlawful means conspiracy. And the bar seems to have been lowered in terms of causation. We also have to bear in mind that to be a conspirator, a party need not know that the unlawful means are unlawful. So if the racing partnership is followed, action agreed between a parent and a subsidiary, which amounts to breach of contract by the subsidiary against a third party, but which the parent does not know is breach of contract, can be actionable conspiracy between the parent and the subsidiary, actionable against both. Even if the breach of contract is, in essence, completely irrelevant to the claimant. So the irrelevant breach of contract with a third party can give rise to subsidiary and parent liability, when otherwise there would be no claim by the claimant, no liability to the claimant at all, which seems to me to be an extraordinary legal risk so far as the subsidiaries are concerned, and an even more extraordinary risk for parents. Thank you.
Thank you, John. We've now reached the part of our seminar where we open up the discussion. Thank you to those who have already posted questions or observations or comments on the Q&A or chat functions, or the people who've submitted questions in advance. If you haven't done so already, please feel free to do so now, and I'll continue to monitor it during our discussion. But I'm afraid Simon Rainey and Nigel Cooper, no comments on either of your talks so far. So I'm hoping that you're going to chip in and answer in relation to some of the other questions and comments and observations on the other talks that we've had. It won't surprise anyone that one of the topics which generated the most debate thus far has been the Libra decision, the Supreme Court decision, which only came out a few weeks ago. John, there are a couple of questions, John Russell that is, on the Libra. The first is in the chat function, and it was asking you to expand on what you meant by the term the attribute threshold, notwithstanding that you've very clearly made the position clear that that's no longer part of the requisite legal test, but perhaps you can explain what you meant by that.
I try not to be facetious, but not really. Because one of the reasons why the Supreme Court has rejected the suggestion there's an attributes threshold is because Lord Leggett asked my opponent in argument, well, you say that there's an attributes threshold. What do you mean by that? How is this a useful test? And there wasn't really any clear answer to that question as to why it would be a useful test. Essentially, I think the argument that developed from cases such as the Aquacharm and the Apostolus was that there had to be something inherent to the vessel and its workings, and had to be a defect in something inherent to the vessel rather than something extrinsic. Before you got into the territory of unseaworthiness. Now, I think that's still going to be the case because, in a sense, you can't have a defect unless it is something to do with the vessel. But there's no, it now doesn't form a sort of a threshold requirement before you get into unseaworthiness as a matter of law. It's obviously still going to be a relevant factual question because a vessel isn't going to be unseaworthy as a result of a state of affairs that have got nothing to do with the vessel, nothing to do with the vessel itself.
Okay, and
John, can I just chip in as I don't have any
sure.
questions? You remember you and I had a case about that big ship that caught fire in Bremen, and part of the problem was that a crane collapsed onto the ship, and I remember you arguing that for the cargo that was yet to come, the ship was unseaworthy because of the presence of the broken crane all over its cargo holds. I can't remember the facts now. How does that fit with what you just said?
Well, I think that it improves the cargo owner's position that there's no attributes threshold because it removes the argument that a vessel cannot be considered to be unseaworthy because of the presence of something else on the vessel, because that's not an attribute of the vessel. It seems to me that quite plainly, if the vessel can't go to sea safely because there's a great big crane collapsed on the deck, then that can constitute unseaworthiness. You can't avoid that consequence by saying the crane isn't an attribute of the vessel. It arises also in relation to in the Apostolus, which was a fire case.
Yeah,
it was argued that the fact that hot works were taking place on the deck couldn't render the hold uncargo worthy because the carrying out of works wasn't an attribute of the vessel. It seems to me that's no longer an available argument because if you have hot works being carried out on deck and you have sparks from the hot works raining down into the hold, liable to set cargo on fire, that does make the hold unseaworthy, regardless of whether you might say whether you say that the carrying out of hot works is an attribute of the vessel or not.
Yeah, I mean, I've always found the attribute argument very difficult because, in one sense, you could describe a defective passage plan, which is sitting on the chart room table, as being an attribute of the ship.
Yeah,
it depends what you mean by attribute, which is no doubt why your opponent struggled to try to define it in a way that was helpful. And just as in our case, I mean, a crane that's lying all over the deck of the ship, which has fallen from the shore, that ship now has a crane on it, which is an attribute of the ship. So I think it's a very circular argument.
Exactly that indeed circular was exactly the pejorative term that Lord Leggett applied to the argument when it was
Okay,
think perhaps circular and unhelpful. I can't.
Sticking with the Libra then, I'm going to ask the panel for their views after John's given his. We've had one question which relates to the example that John gave during his talk, which was a passage plan is correct, but it's ignored during the navigation. And John suggested that that would be falling within the navigational exception. And the question that we had is, what would be the view where a passage plan is done, but afterwards a notice to mariners has been overlooked during the course of the voyage and the passage plan wasn't amended, and then there was a grounding which was causative. John, any views on that scenario?
Yeah, I think this emphasizes how fact sensitive the whole area is, because prima facie, you would say, if the notice to mariners is issued after the voyage has commenced, then that is not on seaworthiness before and at the beginning of the voyage for the purposes of 3.1. Failure to pay heed to the subsequent notice to mariners will be caught by the negligent navigation exception in 4.2a, and therefore the carrier is not liable. But it's not as simple as that, because what are the systems for ensuring that notices to mariners that are issued during the course of the voyage are made available to the vessel? What does the passage plan itself say about monitoring during the voyage for new notices to mariners? What systems are in place? What electronic systems are in place for physically ensuring that the vessel can get updates to notices to mariners during the course of the voyage, and so forth? So, as I say, the easy answer is to say no. That's illustrative of the temporal divide. But I think it's also illustrated in reality of the factual complexities, and you have to always look at whether the subsequent failure is due to something that should have been addressed before the commencement of the voyage. It's interesting. I mean, one area where there's been a big change in relation to the to passage planning and navigation generally is obviously the move to electronic charts and navigating by ECDIS. Now, previously, question of whether the charts are up to date would be judged at the commencement of the voyage, and there'd be an obligation on the carrier to make sure that all the relevant charts are on board at the commencement of the voyage. But now you can download electronic charts as you go, and it raises the question whether, from a carrier's perspective, there's an argument that you don't have to have all the charts downloaded before you start, if you can download them during the course of the voyage. But looking at it, from cargo's point of view, you say, well, that may be right, but you've got to have some sort of system in place to ensure that if there are chart updates issued during the course of the voyage, you get those on the vessel, and you're not simply proceeding on the basis of charts that have become out of date during the course of the voyage.
I understand that. Sticking with the electronic then, we have a question for Michael Howard on electronic bills of lading. So this is your one, Michael. In an area where cybercrime is ever increasing, is there a danger that computerization will lead to an increase in the level of fraud affecting international shipments of goods?
Well, there's no limit to the ingenuity of criminals, and there are obviously a lot of unknown unknowns associated with electronic bills of lading. At the same time, the general feeling appears to be among those who know about these things, of whom I am not one, that the fact that the systems are going to work on the basis of DLT, distributed ledger technology, means that they are going to be more secure rather than less secure than conventional paper bills of lading. It's quite striking in Scrutton on charter parties, there has for at least 60 years been a note saying that despite the fact that paper bills of lading are a tremendously easy target for fraud. There are only 2 reported cases where the fact that they are issued in 3 copies has given rise to litigation. So your guess is as good as mine, but as I say, wiser heads than mine think that there is less rather than more prospect.
Well, I'm not suggesting they're wiser heads, but we have other heads on the panel. Would anyone like to chip in on this question?
I can't comment on the security or otherwise of electronic bills specifically, although I can well anticipate, like Michael, that those introducing such systems will take steps to make sure they're secure. But more generally, does the question of computerization increase the risk of fraud? Then I think the answer to that is obviously yes, and one can see that from all the steps that are being taken by bodies like the IMO, Bimco, and indeed the P&I clubs and others, and major ship owners, to ensure that they have adequate cybersecurity procedures in place. And indeed, for example, you have the Bimco cybersecurity clause that seeks to allocate risk for cyber, the potential introduction of cyber risk by one or other party to a transaction. And all of that points, together with the statistics associated with things like ransomware attack, to the increasing risks that need to be met.
No, I agree. I mean, we're going to see, I think, a few cases about the contractual allocation of responsibility where there is a cyber attack, which party is responsible and who's going to pick up the tab for that. We have one question for John Passmore, which is really to give some views on the impact of the talk that you gave to breaches of shipping contracts and parent and subsidiary groups in the shipping industry in particular. Can you think of any examples where this might arise, or explain how your talk might be relevant to the shipping industry more specifically, John?
Yeah, thanks. I saw that from Anna. Well, yes, I can think of lots and lots of examples. Any contract at all, in effect, subject to the causation which I talked about, subject to there being more causation than the illegally swift pizza delivery drivers. Yes, contracts breached by subsidiaries, contracts with third parties, where that action is agreed between the subsidiary and its parent, could give rise to a claim for unlawful means conspiracy, even if the parent does not realize that that is a breach of contract. I mean, the potential examples are limitless.
Yeah, I agree. I'm afraid that we have got some further questions, but that's really all we have time for on this particular occasion. Ordinarily, I'd ask the audience to show their appreciation to the speakers for the insightful and useful presentations. But as that's not possible, can I thank you, each of the 5 of you, on everyone else's behalf? And can I also thank you on my own behalf for sticking to time and making it so easy to moderate this discussion today. At the start of today's seminar, I said it would be topic-filled and a lively event, and you certainly all delivered that and much more. And all that remains for me to say is to thank the audience for attending, and that we at Quadrant very much look forward to next year, where we hope to see you back in person at the Piraeus Marine Club. So thank you very much for logging in.